Good morning, afternoon, everyone. I hope you've all been keeping well. My name is Inge Kinderman, and I'm excited about being your host on what we're calling the virtual couch today. And thank you for joining us for this session, COVID-19 insolvency reform, debt hibernation, or zombie creation. And what we're sharing with you today is a trans-Tasman overview. Before we kick off, just a couple of housekeeping matters. The first is we are bound to have some technical issues today. It'll probably be me pressing the wrong button, I'm sure. So if that does happen, or when it does happen, please bear with us. We'll do the best that we can. Polly, unfortunately, has had to pull out at the last minute due to an emergency. So we're very pleased to have Matt Kersey step in. Amazing effort, Matt, to step in at the last minute, and thank you so much for doing that. You're all encouraged today to ask any questions by using the Zoom chat box. I'll keep an eye on that chat box, and what I'll do is squeeze in some questions for our wonderful speakers as we go through the session today. So let me introduce you to our guest speakers that you'll see on screen. We've got Sam Kinsey and Matt Kersey. Sam's a partner in the Melbourne office of KWM, specialising in restructuring and insolvency. And Matt is a partner with Russell McVeigh Auckland with equally impressive insolvency credentials. Both Sam and Matt are experts in their field. They've got a huge amount of experience, worked on many high-profile corporate insolvencies, and are at the forefront of law reform in this area. Thank you for joining us, Sam and Matt, and good luck today. With today's presentation, there are two main parts to it. The first part will be a recap of the insolvency reforms that have come through due to COVID. And part two will be looking at the impacts of those reforms so far. And then a little bit of crystal ball gazing at the end as to what we think might happen next. So let's get going. Insolvency reform. Insolvency has particular significance in Australia because directors can be subject to both very significant criminal and civil liabilities if they trade whilst insolvent. This potential personal liability is a strong motivator for any company director to take action, and some commentators suggest that it can lead to directors prematurely appointing administrators to the company, which can be value destructive. So Sam, can I start with you first, please? What changes has the Australian government introduced to deal with this issue or concern?
Thanks, Inga. So after pushing very hard for over a decade in Australia for a safe harbour for directors from personal liability for insolvent trading, pre-COVID, finally in 2018, we got one. So since 2018, as many people on this call will know, Australian directors have had a safe harbour for insolvent trading, and that is where the directors have adopted a course of action that's reasonably likely to lead to a better outcome for the company than an immediate administration, liquidation, or winding up of the company. So that safe harbour requires directors to take positive steps in relation to the plan, and indeed to have a plan. And the government has said that hope does not constitute a plan. So Australian directors were already in a better place than they had been previously in the lead up to COVID. However, once COVID hit, the government took the extra step of suspending insolvent trading liability for Australian directors in respect of debts incurred in the ordinary course of business, which to my observation has had a pretty significant impact on the way directors are responding to the COVID-19 crisis. Now, there's two interesting things about the suspension of insolvent trading liability, which is firstly, it only applies to debts incurred in the ordinary course of business. So to the extent that, for example, you're a director of a retail business and you're wanting to incur debts in building an online part of the business, which is different to the way the business is previously operated, there is concern that this suspension of insolvent trading liability won't cover that. The other important exception to be aware of is that the suspension doesn't apply to criminal liability. So to the extent that directors are acting dishonestly in incurring debts that they know the company will not be able to pay, directors are still at risk in that situation. And the third thing that directors are all very aware of in Australia is that ordinary directors' duties are continuing. And most importantly, the duty of care and diligence and the duty to act in the best interests of the company are continuing as per usual during COVID. So New Zealand has had some interesting changes as well, Matt. What's been happening on the director front in New Zealand?
Thanks, Sam. Yes, so we similarly have brought in some amendments here, and I'll talk about these three these three bullet points here. The first one, I think, was very much inspired by the rapid response from the Australian government, and there was quite a call from a number of quarters for a relaxation of duties in New Zealand when lockdown first hit. And I think probably for many businesses, inspired by the decisions that they were going to have to make, directors were going to have to make about taking on liquidity facilities without necessarily knowing where the pathway for the business was going to be and how long the effects of COVID would last for. So the first thing that we did in that respect was to introduce a sort of another safe harbour for directors in New Zealand, and it's a safe harbour from our equivalent laws around insolvent trading, which are the reckless trading, which is section 135 of the Companies Act, and I guess wrongful trading or insolvent trading, which is 136, which is incurring obligations without having a reasonable basis to believe you'll be able to pay them back when due. So those two together are our suite, and we've got a new sort of safe harbour procedure, which is to apply retrospectively from 3 April. So the legislation didn't come out for a while, but the government announcement said it will apply retrospectively so as to bless decisions essentially already made. But there are quite a few hoops to leap through. It only protects businesses who were able to pay their debts as and when they fell due as at 31 December 2019. So the company needed to be viable in the first place for the directors to have this protection. And then there were a number of conditions that the directors needed to meet. So it's reasonably prescriptive in terms of being able to meet, and I think you'll either meet it or you won't. It needs to be a good faith. Decisions need to be made in good faith, and amongst other things, the directors need to be able to certify that it's more likely than not that the company will be able to pay its due debts on or after 30 September 2021. So they need to make a decision when taking decisions in relation to the business that they're directors of, that they'll be able to trade out of this or come to some sort of compromise within the next 18 months. It's quite a long sunset to plan to and to form a view around, and there's been discussion around how you actually meet this. But that's our safe harbour. It's essentially a conditional excusing of our wrongful trading and reckless trading provisions. We then also went another step further and brought in a new business debt hibernation procedure. This too was inspired in a couple of ways by Australian corporate insolvency law, and that is to provide, it's essentially a short-term new insolvency procedure, but it has a couple of features which are very directly linked to Australian features. It's a short-term moratorium. It could be commenced very readily by notifying the registrar of companies that you're going into what we call BDH, and it prevents any creditors from taking action against the company while it's in BDH. And it can be divided into two parts. There's an initial 1 month during which the company simply has triggered the moratorium, and then creditors need to agree to extend it for another 6 months. And that the bit that is taken from Australian law is that the threshold of creditors agreeing only needs to be 50% in value and number. And that's a departure from our existing laws around deeds of company arrangement and voluntary administration and creditors compromises, which require 75% in value of creditor support. So they lowered the threshold to make it a bit easier to get creditor support. But it doesn't actually bring about a restructuring of debt. It's only a deferral of debt. It can't restructure the underlying debt itself. GSA holders are a significant exception, so GSA holders will still be entitled to enforce and appoint a receiver at any time. But there is a little bit of devil in the detail there in terms of the ability of the creditors potentially to remove payment defaults by deferring payment terms. The other element that was borrowed from Australia is a prevention of parties being able to rely on ipso facto clauses. So the ipso facto exception was brought in Australia, I think, in the same round of reforms that Sam referred to when Safe Harbour came in, or somewhere around that time. We don't have that as a feature of any of our corporate insolvency law, but it is brought in for this purpose. So that is intended to prevent the collapse of the business with counterparties terminating contracts, such as leases and other supply agreements. So those are the two major parts. There's a bullet point there that refers to a change in our avoidable transactions. That's just an important one to note, that now there is only, for voidable charges and voidable transactions or preferences, there's only a 6-month vulnerability period or hardening period for monies received or charges taken, unless you are a related entity. So again, bringing it closer into alignment with the Australian position.
Thanks, Matt. So the New Zealand debt hibernation regime is a formal regime that really sits alongside the existing insolvency appointments. So it's really something that's cutting edge, isn't it? Australia hasn't taken that path of introducing a whole new regime. It's done some other things, which I'll ask Sam to talk about in a minute. But just at this early stage, is there any information available on the number of companies that might have taken up this regime?
Yes, we do have some data. Sorry, I'll flick back to that. I probably went across a little fast to the next slide. Yes, so we do have some data. It's already a week old, and when I think about it now, given the sort of the time periods, it's possible that there are more companies in it, but only 22 entities have now entered BDH since it was brought in back in May. Now, of those, 15 are in the 1 month protection period. So, in other words, that's been commenced within the last month. 2 have got through that first month into the second chamber of 6 months, which again, that may have moved over the last week because we had 15 who were in that process and they may have moved. 3 have expired after the 1 month period, so clearly didn't get the support of creditors or chose not to seek it after the 1 month period, and 2 have been cancelled. So not a huge take up at this point in time, but I think for reasons that we maybe will look at later on, there may be other circumstantial reasons for for that. But clearly it's only one tool available to companies. It was intended to be reasonably quick and easy to bring in, but it's not going to bring about a restructuring of the business that many businesses would need.
Yeah, okay. But back to you, Sam. So if you can just talk us through some of the changes that the Australian government has introduced to try to achieve this debt hibernation for companies.
As with many things, the Australian government has done a much less impressive version of New Zealand's business debt hibernation scheme. But for as we will discuss later in this session, it's nevertheless been quite effective. So what the Australian government has done in terms of creditor protection is they've made some changes to statutory demands and bankruptcy notices. So a statutory demand is a tool, for those of you who are not familiar with it, that you can use if you believe a company is insolvent and you have a debt that is unpaid and there's no dispute about it. So the change for statutory demands is the amount of a statutory demand has gone up from 2,000 to 20,000, and the period during which a debt must have gone unpaid before a winding up application can be brought has gone from 21 days up to 6 months. Similar changes have been made as well in relation to bankruptcy notices for individuals. So the amount of a debt that must be unpaid before a bankruptcy notice can be issued has increased from $5,000 to $20,000 and also out to 6 months. So those tools, while they're very simple, have actually been very effective in that if you are a creditor, unsecured, and you are owed money, statutory demand now, you're waiting 6 months. And the effect of that change has been that, in fact, all sorts of creditors have just found themselves in the situation of being told, we will pay you in 6 months, thank you very much. That's the rule now. That's what the government has said. So the market seems to have interpreted this change in the law as a government-sanctioned extension of creditor terms out to 6 months, is what we are anecdotally hearing out there in the market. The other thing that has been of assistance, I think, is that financiers have been very cooperative in terms of granting extensions, interest and payment holidays. Obviously, as with the New Zealand scheme, none of these tools are solving any problems. They're kicking the can down the road. You know, the debts are still there, interest is still accruing, but during this interim period where revenues are impacted, they've nevertheless proven to be quite helpful at allowing businesses to conserve what cash they've got while they're in hibernation.
Thanks, Sam. And we've had a question come through regarding the statutory demand changes, a good question, and I'll read it. Do any of the COVID changes relating to statutory demands prevent a creditor from suing a debtor for an amount owing where there's no dispute about the debt or the amount owing?
So the answer to that question in Australia is no. You can still sue on your debts. The challenge you will have though is whether that will assist you in collecting on those debts within 6 months. What you could do is bring a proceeding in the county court expedited cases list, for example, get that on for hearing within 3 months. You might get a judgment within 6 months, but you are then left with the question of how you're going to enforce that judgment. So I think for a lot of people, they've come to the view that that's not necessarily going to provide them with a quicker recovery option than waiting the 6 months on a statutory demand.
Thanks, Sam. I mean, the statutory demand changes were very interesting because they were really coming at a time where there had been a big push by small business advocates, for example, Kate Carnell, about the importance for small business of people paying on time. And we did see the introduction of, for larger businesses, publishing their reporting payment times, and the government in certain instances stepping up and saying that they would reduce their payment times as well. So that this is actually quite an interesting thing. I'll be keeping an eye on whether it's extended, and what we hope doesn't happen off the back of this is that there's a change to payment behaviours that we see coming in permanently, rather than the shift back to let's pay our debts quickly to keep that cash flow coming in for businesses. So thanks, Sam and Matt, for the update on that. We know that the impact of COVID has hit certain sectors more than others, and retail was already doing it tough. Since the COVID outbreak, a number of national and local retailers have closed their doors. Some is only temporary and some for good. And we've seen a number of formal administration appointments, with the CFOLI announcement just this week. Sam, can you tell us about what the Australian government has done to provide relief for suffering retail tenants?
So we have in Australia the National Cabinet Mandatory Code of Conduct. Thanks, Matt, for putting that up, which provides a couple of things. It basically provides a moratorium on evictions for non-payment of rent, and also provides for, hi Logan, and also provides for an obligation on parties to negotiate. You know, what's interesting about it, and the contents on the slides, is it in many respects doesn't really matter what the law says on this topic. What we have observed tenants doing in Australia, and Solomon Lew is the most famous example of this, is Solomon Lew just informed all of his landlords that he will pay them when he's ready, thanks. And the problem is, particularly for retail landlords, what are you then going to do about that? Even if you're not bound by the code of conduct, you're left with the problem of having a shopping centre that may be open, may be shut, and demand for your retail tenancy space is low. So what we are observing many retail landlords are thinking about is actually, in many respects, they're better off supporting their existing retail tenants to stay in the tenancy and hopefully come out the other side with a viable business and a shopping centre that has a lot of foot traffic, rather than trying to exercise their legal rights, which is, you know, it's always interesting when it sort of doesn't matter in some respect what the law actually says on this topic, when conditions are as they are. And the same is true for commercial tenancies as well. What's going on this front in New Zealand, Matt? I think you've got some similar sorts of protections in place.
Yeah, that's right. So the first thing that we do have, that last bullet point there, the sort of the formal support was to extend Property Law Act notice periods. So the notice required before you can cancel a lease was extended from 10 working days to 30 working days to 6. So in other words, to 6 weeks. I'm not sure how many PLA notices have actually been served, though, even with that extended notice period, because I think it's been a very pragmatic approach taken both by landlords and tenants. We've got a provision generally known as the Christchurch clause, because it was introduced after the earthquake in Christchurch, when a number of tenants were unable to get access to their what was called red zoned offices, which were after the earthquake were damaged and unable to be entered. So people were unable to use their premises, and they didn't have any relief for that. And the clause that the Auckland District Law Society put into its standard form lease then worked its way into many, either people who have that standard form lease or others who have incorporated it into their commercial lease with their landlord. And that gives a sort of discretionary, discretionary a formula which says that the tenants are required to pay a fair proportion of the rent and outgoings where they're unable to gain access to the premises. So that obviously is not an actual formula or a number, but something that can be determined and can be determined by arbitration if need be, in terms of what is a fair proportion. So that really just sends tenants back with a contractual right to a reduction in rent, and landlords knowing that there is a contractual obligation on them to reduce rent, but they don't of course know by how much. So that's certainly a feature, but I know of many who don't have that clause are arguing by analogy that that's the right thing to do, or that's all they can do in circumstances where they don't have that contractual right, and sort of leaning on the sort of the business morality type argument. So that's sort of been our position so far. So not a lot in terms of legislative intervention. There was an announcement by our coalition government, the Labor-led coalition government, that they were going to bring in a legislative change which implied that Christchurch clause type of arrangement into commercial leases generally, and then requiring disputes to be resolved through arbitration, which can't be otherwise resolved by agreement. And but that was blocked by their coalition partner just recently, such that it's been shelved and nothing has actually come through. So no wider relief is available at the moment. Whether that comes on board in a different form sometime this year before our elections in September, and I think that's partially what's influencing the behaviour here, is a recognition that we've got a general election under our MMP system in September. So whether some other arrangement comes along, or a less interventionist approach is agreed, remains to be seen.
Thanks, Matt. Really interesting on the Christchurch clause and how that might have meant that the New Zealand response to this might have been not the same as Australia. The last topic before we move into part two, which will talk about some impacts that we're seeing so far, is most of the reforms that we've spoken about are pushing out or delaying payments for when businesses recover, and that may free up some cash in the short to medium term. But Sam, what are some of the other things that have been introduced to immediately get cash into a business?
Sure. So thank you, Matt. We would be remiss in giving this presentation and not talking about JobKeeper, which in Australia is a program, a very generous program actually, where for entities that qualify, they are given a $1,500 fortnightly subsidy per employee. Now, to qualify for JobKeeper, an entity had to meet certain requirements, and those requirements relate to a fall in turnover since COVID has occurred. So there's a different test depending on whether the business has less than or more than $1 billion in turnover. But this program has been widely taken up, and as I said before, it's very generous. It's putting a lot of cash into businesses, which is a huge assistance. The other thing that has been of assistance is the ATO has also been deferring, providing some ability for businesses to defer paying tax, and is also putting a hold on some enforcement action, which is helpful. And the third pillar, before we go to some of the industry-specific schemes, is the bank loan guarantee for SMEs. So the government is guaranteeing up to 50% of new loans to SMEs, where those loans are up to $250K for up to 3 years. And those loans will not require any payments within the first 6 months. So this is specifically a program to encourage lending to small business, which was also put in place right at the start of COVID. In addition to that, there are some industry-specific schemes and assistance programs. There's too many to count. So I've just put a few on the next slide, Matt, which is really tourism, agriculture and education and the airline industry have been the beneficiaries of some specific relief programs. Over to you in New Zealand, Matt.
Thanks, Sam. So not surprisingly, we've got a similar approach in terms of wage subsidy schemes. We have it's called the wage subsidy scheme. It's not quite as snappy as JobKeeper. I do set out the terms there, both the full-time and the part-time employee payments. It was relatively low compliance in terms of applying for it, and quite controversial in New Zealand in terms of who took it up. It was initially available for businesses experiencing a minimum of 30% decline in actual revenue over the period of a projected or an actual 30 days as compared with the previous year, and that comparison with the previous year of being some sort of proxy for the effect of COVID. That is now extended from 10 June for businesses experience a higher level of decline, being at least 40% for the period before they apply. So this has been extended again, whether it gets extended a third time is unknown at this point in time, but that's been a major shot in the arm for many businesses whose revenue is otherwise almost entirely depleted through the period of COVID. There are also some tax measures that I won't get into in detail, but they relate to certainly relaxation of time for filing tax returns and other documents, but also probably most notably the changes to the tax loss continuity rules. So relaxing, bringing, I think, the tax continuity rules closer into alignment with the Australian rules, so as to enable a change in shareholder but a continuation of business and allowing the losses to be brought forward. And that seems intended to encourage investment in businesses that need that support without losing the tax benefits that accumulated losses might otherwise bring. If there was a non-tax law, it seems potentially quite a material contribution to some businesses. We've also tried to make some changes to support loans, what's known as the BFG, not of Roald Dahl fame, but now of Treasury creation, business finance guarantee scheme for SMEs, to make loans available which are Crown guaranteed, so to encourage our finance industry to continue to make loans despite credit risk issues. So the terms are set out there, and also a cash flow loan scheme for small businesses at a much lower level as well.
Thanks, Matt. Now, at this point, I'm happy to announce we have our first technical issue, which is me not being able to access the questions. So apologies for that. Hopefully we'll find an alternative way for those to come through so I can put those on. But thank you for your contribution so far. So we've dealt with the summary of the main reforms that have been put in place. We now want to move into part 2 and look at the impact of those reforms. We are probably 3 months into what most people thought would be a 6-month hibernation. Might be looking like a longer hibernation. So Sam, what are we seeing? What's happening in terms of the main impacts of the reforms?
Thanks, Inga. So firstly, what we have seen in Australia is we have seen some insolvencies, most notably the Virgin Australia Holdings administration is obviously the most significant administration taking place in the Australian market at the moment, and not surprising really when you consider that almost all of Virgin's planes were grounded right at the start of the COVID lockdown. So that's obviously the most significant event that has occurred since COVID hit. We've seen some other insolvencies as well. We've seen, on the list here are just a few examples that we've pulled out. Energy, entertainment, retail. So the PAS group, they are a retail group, including Black Pepper. So this administration does have the potential to impact on my mother's wardrobe very significantly. Also the Colette Group and Sea Folly that Inga mentioned before. So we're seeing a bit of insolvency activity in retail and increasing over the last couple of days. What have you seen in New Zealand, Matt?
Well, similarly, there hasn't been a large number of formal insolvencies. I'm sure there are plenty of businesses which have just essentially sort of shut down. We've listed a few of them. They're probably the sort of defining feature in all of them is an underlying vulnerability, which was sort of identified or exacerbated, but probably all of the circumstances leading to this occurred well before COVID. FE Investments was one of our finance companies, which one of the surviving finance companies actually, where we've seen a major rationalisation through the GFC and over the years subsequent to that went into receivership reasonably early. The New Zealand Burger King shareholding companies, sort of franchisor companies, went into receivership as well, right at the relatively early on there. But these are all with pre-existing issues. Smith City, too. Smith City's a big retail group for sort of consumer items, electronic items, and other appliances and so forth. So none of those with huge surprises. We haven't had a major issue, but in terms of insolvency in the aviation sector, but we have seen large capital raising, some of them quite high profile. So Auckland International Airport raised $1 billion in capital right in the heart of the lockdown. And no doubt each of the airports will be in a similar position, but haven't yet seen anything there. We've seen the bit I'm interested in, as well as the cross-border insolvency activity, and we saw that Thai Airlines, for example, has applied for protection in Thailand, and I think it was mentioned in the media last week that it had sought recognition of the Thai proceedings in Australia, or at least in one of the states. And so whether we'll see more of that sort of action and how quickly we will see that will be interesting, but that could be, some of those could potentially be quite contentious with assets being held across borders or moving between borders in those types of businesses.
And we're certainly seeing the patterns in terms of the sectors that we know even pre-COVID were already under stress. And so Sam, what what are we seeing in terms of how the courts might be dealing with insolvencies? Anything that we're seeing there?
So something that's worth remarking upon, especially to this audience, most of whom I expect do not spend a great deal of time in court, that the Australian courts have been functioning pretty much as usual right through COVID. In-person hearings have moved to virtual hearings, and in many ways with greater efficiency, actually, and fairness to some perceptions, because everyone's sort of on a level playing field on Zoom. So that's been good. The interesting thing is about the approach the courts have been taking is in the administrations where there have been applications to the courts and requests for assistance. So the Collect Group, the Virgin Administration and the PAS Group are three such examples. The court has been giving the administrators every assistance in continuing to trade the business with a view to selling it as a going concern. For example, the courts have been granting quite extraordinary orders, in my view, relieving the administrators of personal liability for things like rent, and also for any potential personal liabilities in respect of JobKeeper during the administration period, with a view to just trying to support those administrators with their endeavour to sell the business. Now that is something that we have not really seen before in Australia. Usually the basic principle of administration is if you want to trade on the business as administrator, you need to pay all the debts during the administration period. So this is quite extraordinary support from the courts to administrations during COVID. What's been going on in New Zealand, Matt?
Well, look, I echo that comment, Sam, about the efficiency of the court. We moved in New Zealand onto audiovisual platforms pretty rapidly. There were definitely changes to the priorities for the courts, but we ran on a program called Jabra for the New Zealand courts, and then actually on one matter, involving a company called Halifax, which is two companies, a company in Australia and New Zealand, which are brokerages under the name of Halifax. We had a trans-Tasman hearing that they managed to facilitate with an Australian Federal Court judge and a New Zealand High Court judge, both on Microsoft Teams, dealing with issues rapidly, which was quite extraordinary, but very efficient, and the timetable was retained. And I think there's been a lot of that. If anything, the courts seem to have been able to speed up because they haven't been sitting in person. So in New Zealand, a lot of applications in insolvency matters are done on the papers. You file the papers, the application and a memorandum, and the judges will deal with it in chambers rather than an open court. And if anything, those sped up because I think the judges were not in the courtroom. And so we've had a lot of similar types of applications. We've mentioned a few there. One of them was where the Encore matter, where the courts supported video conference or teleconference means to have creditors meetings, and there have been a few of those, but I've sat on some as well where they're held by video conference. I know I'm aware of some matters where the companies just did it without the court approval, simply because of the expediency and knowing that there was probably very unlikely to be any material prejudice. Similarly, extensions to the convening periods. We don't have a long history of voluntary administration in New Zealand, and so some of our case law is still fleshing out areas that have been long well understood or developed under Australian law. But that was the Colette Hayman Group, which is CBCH, New Zealand subsidiary, got a second extension of the convening period for what seemed to be the first time under New Zealand law, and then I guess with some commonality there in relation to the shake shed, there was orders excusing the receivers from personal liability for rent in a chain of milkshake stores that operate out of sort of malls and shopping centres. I think we've just sort of noted there's just got to be a little careful with that one, because franchisees did seem to be paying rent as well, so it's not so clear that it was a clear-cut release from personal liability, but it's certainly worth looking at if those circumstances arise again, as having the court providing some flexibility to try and keep a business together and allow it to be potentially sold as a going concern, which was the only real pathway to any return for creditors.
And I think one of the things that we probably all hope for is some of the efficiencies that we've seen come out of COVID, whether it be the video conference of the creditors meeting or the electronic notification to creditors. They're things that we hope will be introduced into the permanent landscape going forward, particularly if we start seeing some volumes and there's a need to be able to deal with a scale of insolvencies. I think those efficiencies will be very important, balanced against if there's any prejudice in the particular circumstances, but they'll be great. Matt, before we go to the next topic, we've had a question come through in relation to the business debt hibernation and whether, from what we've seen, and I think you mentioned so far around 20 odd, any specific sector within the companies in New Zealand that have been using that regime?
Unfortunately, we don't have any deeper data on that so far, and we can't search on it yet. I think you have to know which companies to look for in order to be able to find it on our Companies Office website. So unfortunately, we haven't seen the data on that. That's the raw data that we got from the Ministry of Business Innovation, MB. But I think you'd have to expect that it will be companies that are under some financial pressure from whoever their creditors were and want that sort of short-term protection. And interestingly, we've seen, and I'm probably thinking retailers, hospitality type businesses, I expect. And interestingly, we've seen more companies going straight for our creditor compromise business, compromise restructuring tool, which was not as popular pre-COVID because it comes with no moratorium. You essentially put it up as a compromise proposal, and if creditors don't accept it, you're presumed to be insolvent. So it's a sort of high-risk strategy to try and restructure your business, but I'm aware of a sizable hospitality chain and a sizable retail chain going straight for that and not using the protection of BDH. So I think part of the intention with BDH was that it might be used in conjunction with then a restructuring tool so that they do get a moratorium while they go through the restructure, rather than doing that. These businesses, and those are just the ones that I'm aware of, I'm sure there'll be others, may be actually going straight for the more serious balance sheet restructure that they actually need in order to survive, and knowing that that they have some protection to trade on in the meantime for their directors, and don't have that kind of insolvent trading risk hanging over their heads while they trade, but try and seek a restructure that might be unsuccessful.
Thanks, Matt. So we've had a look at some things that have been happening and how the courts have been dealing with it. Sam, what haven't we been seeing in the insolvency space during COVID?
Thanks, Inga. In my view, this is the most interesting part of this presentation. I think because what we're seeing, and we've collected some statistics here on insolvency activity in Australia in the June quarter this year compared to last year. And what that data shows is that insolvency activity across the board, so administration plus windings up, are significantly down on last year. Now, that's really interesting because I think that's telling us two things. One, I think what it's telling us is, and you'll see this figure, 45% decrease in insolvency activity across the board. I think that's telling us that there are a whole lot of companies that would have gone insolvent even without COVID, who are probably still insolvent, but all of the measures that the government has put in place to inject cash into those businesses through JobKeeper, and also through the protections from creditors and from directors' duties, are allowing those businesses to go into hibernation as well. So there's a whole lot of insolvencies that have just not happened, that will probably still happen in any event at some stage later in the year. And that's before you even take into account the impact of COVID. So I think what everyone in my space has been talking about is just really how surprising it is that insolvency activity is so down. And many of the insolvency accountants who you would expect would be, running around out of their tree busy, are actually quite quiet at the moment while these government protection measures remain in place. And I think things like JobKeeper as well while that's in place, it's very hard to make some decisions to restructure your business, because some of the restructuring options that might exist might have a negative impact on the availability of things like JobKeeper. So it seems to many businesses, I think, in the short term, that actually now is possibly not the best time to initiate a formal insolvency process.
And we see there the 60% decrease in court windings up. We know that the ATO is often one of the largest petitioners for winding up companies for outstanding tax. Do you think that a softened enforcement approach from the ATO has had an impact on those stats?
I think so. And I think the other factor that is an input into that statistic is the changes to the stat demands, because very often a court winding up will come after a expired stat demand. So I think what we're seeing there is, to the extent that any stat demands have been issued over the last quarter, they haven't expired yet. So they will expire at some point around September, October this year.
Thanks, Sam. And Matt, any similar stats for New Zealand?
Yeah, absolutely. And it is fascinating, although when you reflect on it, logical, that we've had far fewer insolvencies, corporate insolvencies in New Zealand than at the same time last year and the year before. Sort of starting at the second bullet point in April, which is during our lockdown, there were only a third or less than a third of the number of appointments as there were in the last 2 years. And I think even at that point, I certainly know, I think I can share anecdotally conversations around people wanting to know how, even if they wanted to appoint an insolvency practitioner, how would they go about doing that? What was lawful in that period by way of activity in New Zealand, because we did have a fairly severe level 4 lockdown where the question can be asked, if you were appointed as a receiver to a business, what could you do in terms of actually going in there and inspecting the business or taking any sort of action. So but certainly the court activity will have slowed down through that, and new court activity, as you say, and driven often by the Inland Revenue Department, who do wind up a lot of companies, that will have slowed down materially. It sort of grew in May to 50% of last year's pattern. So maybe that is a pattern which will continue when we see June's statistics. But I think that coalition of factors being government support, the inability to take action readily, uncertainty around what is the purpose of taking action, and in fact probably a little good money after bad type thinking, where people have really been wanting to be careful with their cash, not spend money chasing money that they're not going to get back. The spiraling of in some industries of debt claims where you may be owed a certain amount of money, but is there any prospect of your debtor paying you when they are in turn owed money from somebody else that you probably possibly know about? You can think of, for example, the construction industry as being a good example of that, where there is a chain of payments in reality, regardless of what the legal position might be as to whether you should be paid. So we've certainly seen that down, and I think the economists generally also refer to the sugar hit or the morphine shot or whatever sort of analogy, that government support and also the bounce, the human-driven spending bounce that we've had here in the hospitality and retail sectors, people going out and spending money on not only on sort of fast-moving items, and there's a lot of stuff there in the electronic sector through lockdown as people bought PlayStations and new TVs. If they're going to be stuck at home, they wanted to at least entertain themselves. But since lockdown lifted, a surprising large capital item expenditure has been observed. People spending their holiday budgets that they might otherwise spend travelling on home renovation and other sorts. So all of these factors, I think, are sort of playing together at the moment anyway.
So the stats are extremely interesting, and they'll be particularly interesting post what some people are calling the cliff in September, October, when the majority of the reforms, at least as we know it today, will be dropping off. So now for the last part of the session, and before we wrap up, just some crystal ball gazing, which is always a lot of fun. And from each of you, please, what are a few predictions for what you think we're likely to see when we do get to that cliff face in September, October, with or without an extension to the reforms? Sam?
So what this slide indicates is that there are a lot of businesses in Australia at the moment taking advantage of JobKeeper. So it is going to be really interesting to see how those businesses manage post JobKeeper coming off. I think how they will manage will depend on whether our economy has opened up by then. Being a Melbourne dweller and still being quite in lockdown down here, it's hard to really see that the economy will be back to normal by September. So that's a wait and see. The one observation I have is all of these measures, and Matt made this comment before, they're not solving any problems. They're kicking the can down the road. So while landlords aren't being paid, rent is continuing to accrue. While banks aren't being paid, interest is continuing to accrue. Creditors are not waiving their debts. So I think what we're going to see in September is we're going to need to see a lot of restructuring activity taking place and strategic administrations taking place come September. That's going to be particularly challenging, I think, for small business who often have director personal guarantees and real property mortgages over their homes in support of their business debt. So I think that's sort of what we're looking at in the last quarter of this year, unless the government decides to extend, at least for some industries, some of the COVID policies that are in place.
Yes, I think we've got a similar pattern. I would expect in New Zealand there's a lot of reliance at the moment on the wage subsidy. You can see the number there, nearly $12 billion so far, and let alone whether the scheme will be extended out beyond September. We've got a general election in New Zealand in September, which and of course the US general election, US presidential election as well at the end of the year, creating a lot of uncertainty. But I think we're really only in the early stages now of seeing the impact on businesses when unemployment starts to really rise, and some businesses that might not seem initially as vulnerable start to be affected, and we see if we really do then potentially see more of an extension into our property market and beyond. But we've had I think absolutely the ability to travel is a major impact on our export sector, including our education sector, which provides something like 5% of GDP in terms of overseas students who aren't allowed into the country at the moment, and our tourism sector more broadly is one of our very top export earners. And so how they come out of this winter and when the borders open is the big question. You seem to be heading in one direction so far, but we've seen a little bit more community transmission in New Zealand as a result of our quarantine arrangements, and a fair bit of talk and concern about how far that's going to go. You can see from the experience in Melbourne how quickly the government will respond if concerned about a deepening community transmission. So even if we don't have that type of trajectory, there's a lot of income which has not been earned in businesses, particularly these vulnerable ones, which will need to be resolved at some point in time. And some of them there may be no capability of actually resolving. There may be very little left for creditors in them, particularly in sort of hospitality, retail spaces.
Thanks, Matt. I can see that we're at just about time, so I'll do a quick wrap up. I think that going forward, we're 3 months into what may be a 6-month plus process that we'll be working through. I imagine that a lot of people are planning for the worst, but hoping for the best, and we'll know more in 3 months' time and definitely be keeping our eye on the stats. To our guest speakers, Sam and Matt, thank you so much on behalf of the association and the audience for sharing your insights. And I think the trans-Tasman overview always makes for a really interesting discussion. And to our audience, I hope you enjoyed today's session. Take care and best wishes for the rest of your day. And goodbye, everybody.
Thank you.
Thanks very much.